afternoon. Please be seated. We have one case on the docket today, 1424-00983. Everybody's here, I presume. I see you want to reserve 5 minutes for rebuttal?
Yes, Your Honor.
Okay. We are ready when you are.
Good afternoon, Your Honors, and may it please the Court. The Court deserves a brief update on recent developments. The record indicates that Dr. Costa suffers from Parkinson's disease. Recently, as the briefing has come in, he was diagnosed with stage 4 cancer, and the doctors give him about 6 to 12 months. So we thank you for setting this case for argument so quickly after the briefing came in. Now, turning to the merits, I want to start with the commercial property, recognizing that there's a risk that some of the murky facts about who knew what when with respect to the residents could overshadow the very clear facts regarding the commercial property and the fact that third parties cannot encumber land that they do not own. So I want to start with that, and then I'm happy to answer any questions the Court may have about the residents. With respect to the commercial property, I want to start with the judicial estoppel defense, which was the sole summary judgment ground presented by the defendants with respect to the commercial property. Then turn to our cross motion for trespass to tri-title, and finally address Zonte Enterprises' tort claims with respect to the events surrounding the commercial property. Now, on the judicial estoppel front, it is extremely easy with respect to the commercial property because Zonte Enterprises made no prior representations in any prior judicial proceedings regarding ownership of the commercial property. And there is not a judicial estoppel exception to the rules for alter ego or corporate form. There were no representations made by Zonte Enterprises or about Zonte Enterprises and the assets that it held. Now, if you look at the prior adversary proceeding in federal district court, Zonte Enterprises was not a party to that proceeding. It was not asked to make any representations in that proceeding. It did not, in fact, make any representations in that proceeding, and it obtained no relief in that proceeding to which it was not a party.
What about the fact that the trustee called it said that the couple owned the property through their sham entity, Zonte?
Well, so there was a loose allegation, but the trustee also said under oath in his deposition, and it's a tab B of the bench exhibits, that he did not expect non-party entities to list their separate assets where the form was solely about Dr. Costa and his wife, Sophia. And there were several other entities that were named parties, and he made allegations about sham transactions and sham entities in that proceeding with respect to those separate entities that were named parties. And Dr. Costa and Sophia did, in fact, disclose the assets of those separate entities because they were parties. But Zonte Enterprises was not a party. It made no representations. It was not asked to do so. And that's why counsel for the defendants have to go all the way to North Carolina to find a case supporting the proposition that somehow judicial estoppel can be imputed across the corporate veil when there's been no allegation nor proof in this proceeding of an alter ego relationship. And so the judicial...
Does it matter at all that this is an equitable doctrine?
It is an equitable doctrine, but as a matter of equity, there's nothing to stop a party based on someone else's conduct. Equity doesn't allow you to bar one party for actions taken by someone else unless the law's requirements for the piercing the corporate veil or alter ego relationships have first been triggered. And there's been neither allegation nor proof of that in this case. And so the sole summary judgment ground with respect to Zonte Enterprises' trespass to tri-title claim fails as a matter of law. Now, we went a step further in the trial court because the historical facts regarding the commercial property are established as a matter of law, and That is the property where Dr. Costa and Sophia are living and where they're operating their business out of. So for their sake, we cross-moved for summary judgment to clear title to that property. And that motion rests on the straightforward proposition that third parties cannot encumber or sell or convey land that they do not own. And there's the difference between a void deed and a voidable deed. A void deed is ineffective from the beginning. A voidable deed is immediately effective until it's set aside. And our point is that non-agents who have neither actual authority nor apparent authority, there is no way for them to bind someone with an immediately effective deed when they haven't been authorized to do so. Corporations can act only through their agents, and there is no evidence that John was an agent of Zonte Enterprises. That is the undisputed testimony, declaration testimony of both Dr. Costa and his wife,
Is apparent
Sophia.
authority triggered here?
No, Your Honor. The Gaines v. Kelly case from the Texas Supreme Court states that apparent authority rests solely on the actions of the principal. And there have been no facts identified or proven by Dr. Costa and Sophia that would somehow clothe their son with authority to act on Zonte Enterprises' behalf. They were out of the country. And that's why it's undisputed that they were out of the country. And that's why their son had to try and pull himself up by his own bootstraps by forging the corporate resolution. And the law doesn't allow you to grant yourself authority to dispose of someone else's property. That resolution is forged as a matter of law, and under the Nobles case, which reiterates the old decision from Olson, when you have a forged grant of authority, the ensuing deed is just as void as if there had been no grant of authority at all. It's a nullity.
Can we talk about fraud? What are the exact misrepresentations made as to both the commercial and the residential property?
So as to the commercial property, we alleged fraud almost as a fallback because it is the defendants who have said that, oh, this is fraudulent and therefore it's merely voidable. And I would welcome them explaining what the fraud is. This was done by a son who made no representations to his parents. That's why it is void, ab initio, as a matter of law. But they can't have their cake and eat it too. So if they're going to say it's fraudulent, we should be remanded to pursue that claim in the trial court. As to the residents, we alleged in the Sixth Amended Petition a variety of misrepresentations and omissions, namely that Dr. Costa and Sophia were misled into believing that they were merely pledging the residents as collateral for a loan rather than parting with title altogether. And the linchpin to that claim is the role of the fiduciary, North Star Title. We realize the normal background rule that you're charged with the documents that you sign, can't justifiably rely on representations to the contrary, so on and so forth. That rule changes when you have a fiduciary. And there has been no summary judgment grounds challenging the existence of those misrepresentations and omissions by either the fiduciary, North Star Title, or by Nick Donani and his group of entities sort of funneling misrepresentations through the fiduciary, cloaking it with indicia of reliability. And so the fiduciary, the role of the fiduciary is the linchpin of the tort claims.
Surely a title company is not a fiduciary for all purposes.
There are limits, and that's something that we can sift out on remand, Your Honor. The scope of the fiduciary duties was not part of their motion for summary judgment, but it was just no justifiable reliance was the primary crux, and they said economic loss rule, things like that. We can sift through the precise contours on remand, but we weren't on notice that we even needed to address that in the summary judgment motions. So we ask this court to reverse and remand the tort claims and render judgment that Zonte Enterprises owns the commercial property as a matter of law. Thank you.
Thank you, counsel.
May it please the court. My name is Scott Wheatley, and I'm proud to present the argument today on behalf of the appellees. This case presents an opportunity for this court to safeguard the integrity of the judicial process and of the courts themselves by affirming the trial court's application of judicial estoppel in this case to prevent the appellants from playing fast and loose with the judicial system to suit their own purposes. I plan to address 3 points. One, as a flexible, equitable doctrine that is intended to promote fairness and integrity of the judicial process, judicial estoppel bars all of the appellant's claims. Yes, even the claims of Costas and Sophia's wholly owned and controlled Zonte Enterprises. If you find that judicial estoppel applies, you do not need to reach the remaining grounds. And regardless, judicial estoppel bars all Costa and Sophia's third-party claims. Period. End of story. Point 2, appellant's fraud claims are barred for lack of justifiable reliance and lack of duty. And 3, appellant's motion for partial summary judgment was correctly denied because the undisputed facts make clear the only deed that matters here, the October 2017 deed, was signed by John as president of Zonte Enterprises. As a matter of law, that deed is not a forgery. It is at most voidable, not void, and it is effective until set aside, which means that defendant's ratification and bona fide purchaser defenses would still apply. This case is precisely why we have judicial estoppel. Context matters. Remember, in John's bankruptcy, the trustee alleged, as Justice Boatman just pointed out, that Costa and Sophia owned and controlled the Zonte compound, that is the commercial property, through their sham entity, Zonte Enterprises. The trustee also alleged that they helped conceal and transfer assets worth millions of dollars to defraud John's creditors, and alleged that they and their sham entities observed no corporate formalities whatsoever. When asked, in this context, do you own or have any legal or equitable interest in any real property or third-party claims, they said they had none. No real property, no third-party claims.
Well, they do say that they own 100% of the shares of Zonte, and the trustee had already pleaded that that was a sham entity. So it just seems like the trustee could have done a, if there had just been a couple more steps, we would have a much clearer record here.
Yeah, could have, but the record that we do have is that in the disclosure form that they filled out, they said they disclosed owning 100% of Zonte Enterprises, and then they said its value was worth nothing because they tabulate the value totals in that section. They attribute no value whatsoever to Zonte Enterprises. And 1 month later, after submitting that disclosure to the trustee and getting that lawsuit dismissed, they filed this lawsuit claiming that they're entitled to title to a property that's worth millions. So which is it? And I don't think it changed within 1 month of time. It couldn't have. At base, this doctrine of judicial estoppel is a flexible doctrine. It is an equitable doctrine, and it is meant to be applied flexibly. And as one court put it, it's a gap filler, providing courts with a means to protect the integrity of judicial proceedings where doctrines designed to protect litigants might not otherwise adequately serve that role.
What's your best case to show that Zonte should be bound by
So
that?
the reason why Zonte should be bound is because Zonte is 100% owned by Costa and Sophia. They are the only directors of Zonte. They are the president and secretary, the only corporate officers of Zonte. And under principles that have been applied in the estoppel context, not just in North Carolina, but right here in Texas, So judicial estoppel is one of many forms of estoppel, including collateral estoppel, res judicata, estoppel by deed, etc. Every single one of those forms of estoppel has been applied to privity, those in privity with the person being estopped. And so in that context, you have, in this case, we have privity between Costa and Sophia and Zonte Enterprises
So
because
estoppel doctrines can disregard a corporate separateness?
we're not asking the court to, this is important, we're not at all asking the court to disregard the separateness of the corporate form. That is not what the doctrines would do. What they do is they apply to those in privity with. So Costa and Sophia are in privity with Zonte, and under the facts of this case, you would apply estoppel just as they did right here in the Houston 14th. This Court of Appeals did in the Wilson versus Fleming case, which was citing the factors that the first Court of Appeals announced in the Tejada versus Granada case. So this is in the context of res judicata, but it's the same factors that have been applied, starting with the Texas Supreme Court in the Amstead versus U.S. Brass Corp case, to res judicata and other doctrines. So we have already a well-developed body of law that applies estoppel in circumstances like this based on privity. It's not disregarding the corporate form to say those in privity are also bound because of it's intended to protect litigants against maintaining inconsistent positions before tribunals. That's what we're doing here. And that's the same kind of concept that's at work when you have the application of res judicata or collateral estoppel.
So those cases you're citing, like a res judicata case, it was a prior judgment against shareholders or a corporation, and then they held it against
That's right.
the other one.
So I'll give you an example of right here in the 14th Court. There's a case called Gore Family Limited Partnership versus Gore. It's 2022 Westlaw 1684-5214, a 2022 case. This court applied privity as a bar based on the substantive legal relationship between a general partner and its family limited partnership. Wright Jr. is, in this case, the general partner for the family limited partnership, and the FLP, the family limited partnership, asserted the same legal right. There was a substantive legal relationship, even though Wright Jr. did not appear in the prior proceeding in his capacity as the general partner. Both would benefit from ruling that the stock transfer that was at issue in that case was valid. Privity barred the FLP's claims. So this court has applied that in that estoppel context. It has also been applied. There are two other cases. One is Flightline Escrow versus Lavelle, 720 Southwest 3rd, 415 out of El Paso, 2025 case, applying the same concept of privity between an accountant and his firm, and also in the same case on the other side of the docket between the wife's company and the wife that was suing the accountant and the firm. In that case, the wife was the sole member, had authority to bring suit on behalf of JetZone, the company, and could fairly and adequately represent the interest of JetZone in enforcing the rights. JetZone's claims were barred, as were the claims against the accountant for the same reason. And then finally, another recent 2025 case out of El Paso, Gottwald versus Dominguez Cano. In that case, the corporation's sole principal, director, and shareholder was held to be in privity with the corporation. In that case, barred by res judicata because he maintained complete control over the company during prior litigation. He was the sole administrator, director, officer, and his interests were wholly aligned with the corporation. So again, we're not disregarding the corporate form, we're just saying this is an equitable doctrine and it's meant to protect the integrity of the courts. And so if the court should have the flexibility that it needs in that context to protect the integrity of the judicial process by applying it in a context. We're not saying that corporate form is not important. We of course know that it is in Texas, but you also can't ignore the context that as you pointed out earlier, that the trustee himself alleged that Zonte Enterprises was a sham entity that was owning and controlling this building. And then in response, they submitted a disclosure not disclosing any equitable or legal interest in any real estate or third-party claims, only for a month later to say they had all of these claims that they're bringing
So
today.
what about the second prong about accepting the judicial acceptance of the?
Well, and great, good question. So the court did accept the position. It's in this case, to start, the trustee is an arm of the court, and so the trustee took the disclosures and based on those disclosures, moved to dismiss the case. The district court did accept that motion to dismiss.
But we don't know that it was based on the disclosures, do we?
Right, and it doesn't have to be. So in Bailey versus Barnhart, which is, again, a 14th Court of Appeals decision, judicial acceptance does not require formal judgment. It means only the first court has adopted the position urged by the party, either as a preliminary matter or as part of a final disposition. And also in the Fleming case, which we cite in our brief, hold on just a second. Excuse me, I'm referring to the Brown versus Sweat case, which is cited. And the prior inconsistent position was accepted because the trustee concluded there were no assets to administer for the benefit of the creditors, and the bankruptcy court dismissed the case.
I just don't see where the trustee says that there are no assets. I'm looking at the motion to dismiss, and it, you know, I don't know what this other litigation is that they had agreed, that the creditors had agreed to dismiss. It just doesn't say.
Well, in the record, in this case, we did ask the trustee that question, and the trustee testified, yes, I did my due diligence, and based on that disclosure, concluded that it was not worth pursuing, and that is why we filed the motion to dismiss. That there were no assets that would justify the trustee's time and attorney's fees that were going to be required to pursue those assets. And so that was the reason he gave in response. But in this context, it's sufficient. And the Brown versus Sweat and Crawford case, that's a Houston First Court of Appeals case. That's exactly what happened. The trustee concluded there weren't sufficient assets and asked to dismiss the case, and judicial estoppel was held to apply. That second prong was met. It also, we also meet the prong of lack of inadvertence. As we have fully briefed, the lack of inadvertence is not met here. Inadvertence is, it is not inadvertent when you have the motivation sub-element that is assumed in the bankruptcy context because of the potential financial benefit resulting from non-disclosure. So where you have that motivation sub-element, the burden shifts. It shifted to them to show they weren't inadvertent. They made no showing on that in response on their motion for summary judgment, but nor could they, because all of the facts that we've adduced and adduced at trial showed that they knew what they were doing, and they knew and were fully aware that they both had the claims to the building, were aware that it had been transferred to Global Zonte at that point. They signed a modification and lease agreement with Global Zonte as the landlord and owner of that building. They were well aware that they had signed the deed to the house, and of course the law charges them with knowledge of reading and understanding what they signed, and so they can't say they didn't know about that either. So no, it wasn't inadvertent, and they even plead that their pleading states that they weren't aware of all these facts until April of 2018, which is a year before they filed these disclosures. So even their own pleading makes clear they knew they had these claims, they were aware of the facts, and so the third element is met as well. And I am running out of time, but do you have any other questions about judicial estoppel? Okay. I want to turn quickly to the fraud claims. You asked a few questions about that. Their fraud claims here, first of all of the fraud and breach of fiduciary duty claims are barred if the court applies judicial estoppel. That takes care of everything. Their fraud claims fail also because there's no justifiable reliance here. I mean, the law presumes that the party reads and understands what they signed, and they did sign the deed to the real estate, and so they can't justifiably rely on that. As to the commercial property claim, they claim they didn't even know about it at the time. And so they can't, there's no reliance as a matter of law when you say, I didn't know about this transfer. That means there's no representation made to them if they say they didn't even know about it. So that claim fails as well. And then that's it. Thank you for your time.
Thank you, Joseph. Rebuttal.
2 points on rebuttal, but first, I think I just heard counsel for the appellees concede that there was no fraud as to the commercial property. Their entire claim that it is voidable rather than void hinges on the proposition that there were fraudulent representations made by an agent to the principal. There was no agency, there was no principal. It is void ab initio. With respect to judicial estoppel, I want to talk about the issue of whether there was a representation by Zonte Enterprises, and briefly address the arguments just made about judicial acceptance. The flexibility associated with judicial estoppel does not extend to skipping or eliminating its elements. One of the elements of judicial estoppel is that there was a prior inconsistent representation by the party. And the defendants have just conceded they aren't trying to pierce the corporate veil. They say that privity is the key. Well, we provided citations in our reply brief, page 5, that corporate directors, corporate shareholders are not in privity with the corporation absent an alter ego relationship. And they just conceded they're not trying to prove that. Now, they try and backdoor in a separate line of cases, first time, about privity in the context of claim or issue preclusion. But it's a separate doctrine, and the Fleming case that they cited, one of the issues that the Supreme Court granted but then said, we don't have to quite address it here, is the precise contours of privity for claim and issue preclusion. One of those inquiries is whether there's adequate representation of someone else's interests and things like that. Those discussions are nowhere to be found in the body of law regarding judicial estoppel. That's because the question is whether you, the party, made a prior inconsistent statement. And Zonte Enterprises made no prior inconsistent statements. It made no statements whatsoever. Just as a footnote there, I would point out that Costa and Sophia made no prior inconsistent statements about Zonte Enterprises either. If you look at their personal financial disclosures in the blank for Zonte Enterprises assets, they don't assert that it had no value. They say unknown dollar value. That is entirely consistent with their position right now that they continue to own the commercial property, that Zonte Enterprises continues to own the commercial property, that it has valid tort claims. The second point with respect to judicial acceptance. I think you hit the nail on the head, Justice Boatman, with the fact that the trustee did not provide the federal district court with any of the information that was supposedly the basis of his motion to dismiss. The trustee provided to the district court the reasons for dismissal. The first is the trustee's own due diligence, relying on the statements of the opposing party that you have just asserted in an adversary proceeding committed fraud. That's the opposite of due diligence. He's telling the district court that he relied on his own due diligence, and he is telling the district court that he relied on the outcome of a separate, distinct proceeding.
Do we know anything about what happened between October when they filed that disclosure and May when he moved to dismiss? Were there other proceedings?
There was, so their attorneys, Dr. Costa and Sophia's attorneys filed an answer later in October of 2018, but as far as the details of any other proceedings, I just don't know.
So we don't know what due diligence means?
No, we don't know what it means, but it's certainly not proven as a matter of law that he was relying solely on the statements of Dr. Costa and Sophia, let alone the federal district court was. There's no judicial acceptance. And there is a large difference between a debtor in a bankruptcy proceeding who, by definition, when the debtor obtains bankruptcy relief, is representing, I have no other assets to go after, to individual defendants, not debtors, in an adversary proceeding in federal district court, not federal bankruptcy court, who didn't obtain any relief whatsoever other than just the claims being dismissed. So we stand on the black letter law regarding the elements of judicial estoppel. We ask this court to reverse.
Thank you, counsel. Thank you for your arguments this afternoon. This case is submitted and we're adjourned.
All rise.